Welcome to Audit the Court, where we break down the legal details behind real trials, hearings, and courtroom decisions. In today's episode, we're returning to the Harris County Criminal Court in Houston, Texas, to review several probable cause hearings presided over by Judge David Fleischer. In each of the cases we'll discuss, the judge determined that the evidence presented was insufficient to support the criminal charges. This episode is part of our ongoing series designed to help viewers better understand how probable cause works in real courtrooms and how judicial oversight protects constitutional rights. If there's a probable cause case you'd like us to cover in the future, let us know in the comments below. Let's begin with our first hearing. On February 21, 2025, Edward Love Jr. and Edward Love III were charged with evading arrest or detention after officers alleged they ran when approached. A probable cause hearing was held on February 28th in Judge Fleischer's court.
Good morning. Happy Friday.
Happy Friday.
Michael Love, come up.
It's two, Michael Love and Michael Love Jr.
Oh, really?
Junior and third.
Okay, Michael Love Jr. and Senior, come on up. Who's Junior? And you are the third. Gentlemen, both of you are charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay?
On February 20th, 2025, officer dispatched to First Baptist Church. A caller stated that a white pickup truck parked behind the Baptist Church and two Hispanic males exited the truck and were walking around the property. The officer arrived on scene and observed one of the ground level windows opened and a window air conditioner unit pushed in on the inside of the building. The officers then observed two Hispanic males exit the doors on the west side of the building. The defendants then turn and look at the officers and then run in the opposite direction for approximately 30 yards to C Street, run an additional 20 yards to First Street, and then turn and run an additional 30 to 40 yards. Due to the circumstances of the incident indicating this was possible burglary in progress, the fleeing suspects who could have been armed, the officers drew their duty pistol and gave defendant Love Jr. several commands to get on the ground and allow him time to reply. He disregarded the command, so the officer took defendant Love Jr. to the ground. Defendant Love III ran around the building and then subsequently followed commands to lay on the ground. They were both detained. Defendant Love Jr. stated that they panicked, so they ran. The officer stated, "You looked right at me and knew I was a cop, but you still ran," to which the defendant stated, "I know, bro, it wasn't the right thing to do, sir."
Your Honor.
They look at the cop and they run.
Yes, sir.
Cops never tell them to stop.
Exactly.
And what are they doing wrong? I guess, what is this, Minority Report? You know what I mean?
I don't know anything additional to say.
Guys, be careful. You know what I mean? How old are you, sir?
18.
You gotta be careful, man. When you start racking up convictions, life doesn't get easier, man. It gets so much more difficult. And the more convictions you rack up, you're only 18, man. Life doesn't get easier. You get bigger, fatter, you lose hair. It doesn't get easier. And the more convictions you get, the worse you make life. Life is all about money. And if you have money, then life is great. And you only get it with one thing. This or this. Hard work or knowledge. Going around picking up cases, that's not the right way. Don't pollute. Do you understand?
Sir.
I'm going to find no probable cause on both of your cases.
Thank you, Your Honor.
Take a seat.
Judge Fleischer ruled that there was no probable cause to support the evading arrest charges under Section 38.04 of the Texas Penal Code. This law requires proof that a person intentionally fled from an officer who was lawfully attempting to detain them, and that the individual knew the pursuer was a police officer. Because neither defendant was clearly ordered to stop, the essential element of intentional flight was never established. Without a communicated attempt to detain, the statute simply did not apply, and the state dismissed the charges that same day. Before moving on, a quick thank you to today's sponsor.
I had a guy charged with a felony that was arraigned this morning, but he's on your docket later in the week, and I was hoping just to get it done so we can.
Of course, let's do it.
Okay.
Do you have the cause number?
I do, 255-9578. He's already got conditions from Judge Simons. Where'd he go?
Judge Simons.
Yeah.
Okay.
Judge E. Simons. And so it's my understanding there's no alcohol. He's got a device also already, I think, or at least we can double check.
All right, sir. You are Mr. Kubler.
Kubler, yes, sir.
Kubler. Mr. Kubler, you're charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. I see. So that he's also charged with abandonment. Is it out of the same transaction?
Yeah, but we had a long discussion with him this morning.
I don't know anything about it. Let's find out what's going on, please.
Judge. On April 25, an officer was dispatched to an unknown accident, and noticed a vehicle, a pickup truck, illegally parked in the front yard of the residence. There were fresh tires, skid marks, a broken wheel, and axle visibly appeared to be damaged from the Ram truck to a legally parked red Jeep Compass. The law enforcement officer made contact with the employment, and then it said the damage to the Jeep was probably $5,000. The defendant admitted to driving the truck. Was later identified. The officer also made contact with the wheel witness, who said that he witnessed the defendant in the white truck in the driver's seat behind the wheel and observed an active vehicle from the driver's side door. Upon exiting the vehicle, the wheel witness observed he was not stumbling, and then the wheel witness observed slurred speech and strong odor of alcohol beverage emitting from the defendant's breath and person. The defendant also admitted that he was trying to flee the scene and go home, but his vehicle was stolen. The officer made contact with the defendant, who was detained, and noticed a strong odor of alcoholic beverage. The officer then conducted a standardized field sobriety test, where he witnessed, the DIMS leaves off and does not show the standardized field sobriety test results. The officer asked the defendant his intoxication level. The defendant said he was at a 6 out of 10. The defendant said he does not believe it was safe to operate his motor vehicle at this level of intoxication, but had an 11-year-old passenger.
He did not.
I'm sorry, he did not. He did not. I apologize. Just a moment to see if I can.
Judge, I'm going to tell you that's kind of where the DWI investigation stops. The first response that I have is that no field sobriety tests were performed. It also, the credibility of the wheel witness was never discussed in the DIMS, whether the officer found them credible or reliable, etc. So I really can't make a lot of sense out of.
It's like the DIMS you're reading these, like going through a drive-through, man. I mean, really, who's writing the reports?
Yes, sure.
Over and over and over. I mean, really.
Trying to see if I can find anything else.
Case after case, we're just.
So Judge, things don't say it, don't say or what is the results of those van revealed sobriety tests, and we do not have an officer back there.
How on earth am I supposed to find probable cause when Mickey Mouse is writing these reports?
I don't say. I don't know why it's on the DIMS. Obviously, we didn't write it here. We represent what is written in there, and so I understand your frustration. I'm highly frustrated.
Mr. Kubler, I'm going to find no probable cause in your case. Don't kill anyone. You know, every single day on the news, how many people die in our county because of a DWI? How many? Every single day. We lead the nation in alcohol-related collisions and fatalities because of boneheaded moves that are made day in, day out. Now, this is not to say that they may not indict this case at a later time, but be whatever, just don't kill someone, please. Take a seat, please, sir.
Thank you, Judge.
Judge Fleischer found no probable cause due to deficiencies in the DIMS report, the District Attorney Intake Management System summary used to justify warrantless arrests. The report lacked sufficient factual detail to support the charge. However, on May 23, 2025, prosecutors filed a new complaint stemming from the same incident, charging Mr. Kubler with felony DWI after identifying prior convictions. The original charge was dismissed on May 27th, while the felony case remains pending. Another hearing involved Jonathan Cerna, who was charged with interference with public duties after officers alleged he ignored instructions while they executed an arrest warrant outside his home.
Judge, next is case 21, Serna Jonathan.
Good morning, Mr. Cerna. Sir, you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and/or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
Yes, sir. On March 28, 2025, an officer was in the process of serving a capital murder warrant on a suspect in Harris County, Texas. While conducting a felony stop, the defendant, who was identified by his Texas ID card, pulled up on the officer's perimeter, got out of their motor vehicle, and began walking to the residence where the murder suspect was. The officer's supervisor ordered the defendant to stop and stay right there. The defendant refused and continued to ignore officers while walking towards the residence. The officer's supervisor ordered the defendant to step back multiple times and then grabbed the defendant and took him to the ground.
Him?
Yes, Your Honor.
Was he the capital murder suspect?
No, Your Honor.
I live there. Stop. Oh, sorry.
I believe that they were in the process of serving a warrant on someone else at the residence, and that's when they came in contact with the defendant.
Okay.
He refused to stop going towards the residence, Your Honor.
Did it serve the warrant? What ended up happening?
Looks like after refusing commands, there was a brief struggle where he was detained.
Was the murder suspect there?
I'm not sure, Your Honor. It does not say. I have no further facts that show if the warrant was, if service was complete on the warrant or not, Your Honor, or completed at the time. I just believe they were in the process and believed him to be at the residence and was witness and citizen.
Read it again, if you don't mind.
Yes, Your Honor. On March 28, 2025, the law enforcement officer and squad 5 of the Houston Police Department's gang division served a capital murder warrant for a suspect observed inside a truck at a nearby residence. While conducting a felony stop, the defendant, who is identified by his Texas ID card, pulled up on the perimeter, got out of the vehicle, walked to the sidewalk, and began walking to the residence where the murder suspect was. The supervisor then ordered the defendant to stop and to stay right there. The defendant refused and continued ignoring officers and walking towards the residence. The supervisor ordered him to step back multiple times, but the defendant was once again ignored the officers. The law enforcement officer grabbed the defendant and made him bounce and the ground.
Okay, so now, but when you first started, you said they were going to a capital murder suspect in a car.
Yes, Your Honor. That's what. So I was originally reading the summary, and I'm going straight from the Dems now, Your Honor. It looks like the suspect was observed inside a truck at a nearby residence.
So the suspect is not even in the residence. No.
Then they later state that the defendant here was walking towards the residence where the murder suspect was. I'm not sure, Your Honor. I don't think
I'm gonna find no probable cause in your case. Just be careful, man. When you get into a pissing match with,
I understand.
who's gonna win?
They are.
I understand.
No.
Yes, sir. All right. Hands. Please.
Clip 4. Judge Fleischer ruled there was no probable cause for the interference charge. Under Section 38.15 of the Texas Penal Code, the state must show that a person's actions actually interrupted or impeded an officer's lawful duties. Although Mr. Cerna was told to remain outside, the evidence showed he neither threatened nor obstructed officers, and his attempt to enter his own home did not meaningfully disrupt their operation. Without proof of actual interference, the charge was dismissed the same day. The final hearing occurred on April 25, 2025, after Joseph Ramirez was charged with DWI.
The council's approaching for page 15.
Okay.
Ramirez, Joseph.
Hi, Frank. How are you? You ready? Come on. Hi, good morning, Mr. Ramirez. Morning, sir. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 17, 2025, in Harris County, Texas, an officer observed a pickup truck change lanes without using a turn signal. The officer observed the vehicle change lanes twice prior to initiating the traffic stop. The officer approached and observed the defendant to be the driver and sole occupant of the vehicle. The officer noted a strong odor of alcoholic beverage emitting from the defendant. The defendant was ID'd by his Texas driver's license. The defendant stated that he did not know how to provide proof of financial responsibility. As the defendant responded to the officer's questions, the officer noted an odor of alcoholic beverage emitting from the defendant's breath. Standard field sobriety tests were conducted. A 6 out of 6 was reported on the HGN, and the defendant stated that he could not perform the walk and turn or the one-legged stand. The DIC was read, and the defendant refused to provide breath or blood voluntarily. A blood warrant was obtained, and the defendant's blood was drawn.
Your Honor, may I respond?
Please.
Okay, first of all, Judge, it's not on there for some reason, but the reason he told the officer he can't do it because he had surgery to his back and to his knee. He can't do it. Secondly, there's no mention of any slurred speech, no bloodshot eyes, no swaying.
I mean, I was actually thinking about that as well. All you have is an odor of alcohol. Anything, there's no accident. It's just a turn. All we have is an odor of alcohol. Is there anything else? The odor alone is insufficient.
No, Judge, he was coming from a tattoo shop and the police officer asked him, is he alcoholic because of the tattoo?
Is he what?
He just had a tattoo put on. That's the odor of alcohol.
Come on, man.
I'm just saying. I mean, the officer actually asked him that question.
What are they, the little alcohol that you put on your skin, you tell me that?
I don't know how it works, Judge. I've never had a tattoo.
You're killing me, Smalls.
Your Honor, the law enforcement officer does state in the DIMS that there is a distinct odor of alcoholic beverage emanating from the defendant's breath as he spoke.
Yeah.
That's
it?
all we have before he initiated the standardized post-mortem test.
Okay, that's not enough. All right, I'm going to find no probable cause in your case, Mr. Ramirez.
So,
We have enough death on our streets now. $40. One button will get you a car wherever you want to go in this life. You know what I mean?
Yes, sir.
Use it. All right, please.
Thank you.
Thanks, Frank.
Judge Fleischer concluded there was no probable cause because the officer's only basis for further investigation was the alleged odor of alcohol. Texas law requires reasonable suspicion of intoxication, not merely consumption, before administering field sobriety tests. Since no additional indicators of impairment were documented, the testing was deemed unsupported, and the resulting evidence could not be considered. With no admissible evidence of intoxication, the DWI charge was dismissed. These hearings highlight the crucial role courts play as constitutional gatekeepers in the criminal justice process. In each case, Judge Fleischer emphasized that probable cause cannot rely on assumptions, incomplete reports, or missing legal elements. Whether it was the absence of a lawful order, insufficient factual detail, misapplied statutes, or evidence obtained without proper legal justification, the outcome was the same. The Constitution required more. These decisions serve as a reminder that probable cause is not a mere technicality. It is a vital safeguard against unjustified arrests, ensuring every charge is backed by legally sufficient evidence. If there's a case or courtroom moment you'd like us to analyze next, let us know in the comments. Thanks for watching, and don't forget to like and subscribe to stay informed.